Neil Hamilton.
Well, I welcome the statement. It's perfectly reasonable, I think, that the Counsel-General seeks to intervene in this case brought by the Lord Advocate of Scotland. Devolution is an evolving process, and there is inevitably going to be uncertainties and ambiguities which are created by the legislation which is the means of bringing it about. We moved from a conferred powers basis to a reserved powers basis in a sense that perhaps provides more work for lawyers to unravel the areas of doubt which will continue to remain as experience of life throws up practical problems to be solved. So I do think that the Welsh Government is entitled to take part in these proceedings. In fact, it is vital that we do resolve the ambiguities which are inherent in the Scottish case. And I would like to pay a compliment here to the Welsh Government, as I've done before, in comparison with the Scottish Government, that they have taken a practical approach to withdrawal from the EU and not tried to turn it into a kind of political football match, as has happened in Scotland. I appreciate that there are other parties behind the refusal of legislative consent in Scotland, as well as the Scottish nationalists, but I do think that, although the Scottish position is different because devolution has gone further in Scotland, but nevertheless I do think that the arguments which they're producing are specious and are fundamentally designed to inhibit the withdrawal process. So I'm pleased that the Welsh Government has taken a different view, and it is sensible that they give Wales's voice a hearing in the court as well. And I also think that the four issues that the Counsel-General has identified as necessary to be resolved are the vital questions in this case. I fully agree with the Government's view that all powers currently vested in Brussels, which under the devolution settlement should come to Wales, should be vested here. And it's always been, I think, a paradox that those who complain that the devolution process is being undermined are actually talking about powers that we don't currently have the power to use anyway. So I think the important point that the Counsel-General made earlier on was that the EU withdrawal in this respect does potentially enhance the competence of this Assembly. It gives us more power. It may not go as far as Plaid Cymru would like. I fully understand their objections and reservations. They're entitled to make those points because they don't believe in the United Kingdom as the political structure within which we will continue to exist. I think it is, and I think it's very important that their point of view should be expressed, and that that these arguments should be put in this Assembly, and that the government should defend itself against those arguments. It's very important that this should be done in the most open and transparent way as possible. I also think that it is very important that the Court's powers to review Assembly legislation are further refined through cases of this kind. There will inevitably be areas of uncertainty which need to be resolved, and the common law process, it works by case law, and so we build up a corpus of constitutional law, not just by statutes, but actually more fundamentally in the interstices of the law through individual cases turned over long periods of time into legal principles and conventions. So I think that this is an inevitable step in the devolution process and also in the process of withdrawal from the EU. It's one that I welcome, and I wish that the Counsel-General well in his advocacy for Wales in the case.
Thank the member for those remarks. I think that the very point of devolution is that different parts of the UK can reach different outcomes and different conclusions about how to approach this sort of question. And that is what happened ultimately in this case. The Scottish Government, Scottish Parliament, took a different view ultimately than we did here in Wales. That is inherent in the nature of devolution, and in fact, if you're a devolutionist, it's a thing to be celebrated. Different considerations apply. The Welsh Government was clear from the start that our main objective was to secure appropriate amendments to the EU Withdrawal Act as it is now, and that the Continuity Bill was a means of achieving progress in relation to that. I would also say that we have benefited throughout by working very closely with the Scottish Government in relation to the development of the Intergovernmental Agreement, and subsequently as well. And I think this is the start of a longer process as all parts of the UK withdraw from the European Union. That kind of collaboration and cooperation will, I think, stand us in good stead as we go forward over the coming months and no doubt years. Just on the point which he makes, really, which echoes the point in the Supreme Court case of Miller, i.e. that without an intervention, a legislative intervention, the withdrawal from the European Union extends the competence in those devolved areas rather than limits it. The argument that an Act of Parliament is needed before a devolved legislature can act in an area where EU law is withdrawn is obviously fundamentally at odds with that observation. But I would also point out the intergovernmental agreement, as it was originally conceived, which had the much broader attack actually on the devolution settlement, was accepted by the UK government as requiring, under the Sewell Convention, a legislative consent motion, which suggests an acknowledgement on their part that there's a baseline level of competence even in relation to matters relating to the withdrawal from the European Union. So I think that is at odds with how the Attorney General has put his case here, and I hope that we will prevail in relation to that when our arguments are made before the Supreme Court.
David Rees.
Diolch,